Alrighty, folks. Thank you to musical brother Owen Joel Graham for his contribution to this contemporary culture we live in and to this live stream. So we are reading from Conflicts of Law now. We are into constitutional limits on the choice of law provisions. And we are doing our first case today, Wells versus Simonds Abrasive Company, a United States Supreme Court case from 1953. Chief Justice Vinson delivered the opinion of our court. Cheek Wells was killed in Alabama when a grinding wheel, that's shitty highlighter, a grinding wheel with which he was working burst. The wheel had been manufactured by the respondent or corporation with its principal place of business in Pennsylvania. The administratrix, which means a female administrator, of the estate of Cheek Wells brought an action for damages in the federal court for the Eastern District of Pennsylvania after 1 year, but within 2 years after the death, jurisdiction was based upon diversity of citizenship. The section of the Alabama Code upon which petitioner predicated her action for wrongful death provided that the action, quote, must be brought within 2 years from and after the death. The respondent moved for summary judgment on the ground that the Pennsylvania wrongful death statute required suit to be commenced within 1 year. In an opinion on that motion, the district judge found that the Pennsylvania statute, which was analogous to the Alabama statute, had a 1-year limitation. He further found that the Pennsylvania conflict of laws rule called for the application of its own limitation rather than that of the place of the accident. Deeming himself bound by the Pennsylvania conflicts rule, he ordered summary judgment for the respondent. The Court of Appeals for the Third Circuit confirmed. Long ago, we held that applying the statute of limitations of the forum to a foreign substantive right did not deny the full faith and credit. Recently, we referred to, quote, the well-established principle of conflict of laws that, internal quote, if action is barred by the statute of limitations of the forum, no action can be maintained though action is not barred in the state where the cause of the action arose. Restatement Conflict of Laws, Section 603. Order of the United Commercial Travelers versus Wolf. The rule that the limitations on the forum apply, which this court has said meets the requirements of full faith and credit, is the usual conflicts rule of the states. However, there have been divergent views when a foreign statutory right unknown to the common law has a period of limitations included in the section creating that right. The Alabama statute here involved creates such a right and contains a built-in limitation. The view is held in some jurisdictions that such a limitation is so intimately connected with the right that it must be enforced in the forum state along with a substantive right. We are not concerned with the reasons which have led some states, for their own purposes, to adopt the foreign limitation. Instead, of their own in such situations. The question here is whether the full faith and credit clause compels them to do so. Our prevailing rule is that the full faith and credit clause does not compel the forum state to use the period of limitations of a foreign state. We see no reason in the present situation to graft an exception onto it. Differences based upon whether the foreign right was known to the common law or upon the arrangement of the code of the foreign state are too unsubstantial to form the basis of constitutional distinctions under the full faith and credit clause. We agree with the respondent that Engle v. Davenport has no application here. It presented an entirely different problem. Congress had been given a statutory cause of action to seamen, the boat guys, not the bodily fluid, for personal injuries, placing concurrent jurisdiction in the state and federal courts. In Engle Supra, the 2-year federal limitation, rather than the 1-year California limitation for similar actions, was held controlling in an action brought in the California courts. Once it was decided that the intention of Congress was that the 2-year limitation was meant to apply in both federal and state courts under our federal Constitution, that was the supreme law of the land. Our decisions in Hughes v. Feder and First National Bank v. United Airlines do not call for a change in this well-established rule that the forum state is permitted to apply its own period of limitations. The crucial factor in these two cases was that the forum laid an uneven hand on causes of action arising within and without of the state. Causes of action arising in sister states were discriminated against. Here, Pennsylvania applies her 1-year limitation to all wrongful death actions wherever they may arise. Thus, the judgment is affirmed. Justice Jackson, with whom Justice Black and Justice Minton join in dissent, quote, the essence of the full faith and credit clause of the Constitution is that uniformities other than those within the state are to be observed in the federal system. The whole purpose and the only need for requiring full faith and credit to foreign law is that it does not differ from that of the foreign. But that disparity does not cause the type of evil aimed at in Erie Company versus Tompkins, supra, namely that the same event may be judged by two different laws depending upon whether a state or a federal forum within that state is available. Thus, application of the full faith and credit clause prevents this disparity from requiring that the law where the course of action arises follows the course of action to whatever forum it is pursued within. The court's decision, in contrast with our position, would enable shopping for favorable forums. Forum shopping, they call it. Suppose the plaintiff might have obtained service of process in several different states, an assumption not extravagant in the case of many national corporations. Under the court's holding, she could choose from as many varieties of laws as of forms. Under our theory, wherever she elected to sue, if she had a choice, she would take the Alabama law with her. Suppose even now she can get service in a state that has no statute of limitations or a long one. Can she thereby revise a cause of action that has expired under Alabama law? The court's logic would so indicate. The life of her cause of action is then determined by the fortuitous circumstances that enable her to make a service of process in certain states or in other states. We think the better view of the case before us would be that it is Alabama law which giveth, and only Alabama law which taketh away. Good job. Who the fuck wrote that again? Good job, Vincent. You got a good turn of phrase, brother. That's that case. So no, you got sued in Alabama and you missed the time frame. Alabama, sweet home Alabama, got a 1-year statute of limitations. Arkansas, they love the governor. Boo. All right. Austin versus New Hampshire, U.S. Supreme Court case 1975. John Marshall, Justice Marshall, not Thurgood, but the latter Marshall Justice guy. John Marshall delivers the opinion. The appellants are residents of Maine who were employed in New Hampshire during the 1970 tax year, and as such are subject to the New Hampshire commuter's income tax. That sucks. On behalf of themselves and others similarly situated, they petitioned the New Hampshire Supreme Court for a declaration that the tax violates the privilege and immunities and equal protection clauses of the constitutions of New Hampshire and the United States. The cause was transferred directly to the New Hampshire Supreme Court, which upheld the tax. What a joke. We noted probable jurisdiction for the federal constitutional claims, and on the basis of the privileges and immunities clause of Article 4, we now reverse. Fuck you, New Hampshire Supreme Court. It's coming back down. 1. The New Hampshire commuter's income tax imposes a tax on non-residents' New Hampshire-derived income in excess of $2,000. The tax rate is 4%, except that if the non-resident taxpayer's state of residence would impose a lesser tax than the income a lesser tax had the income been earned in that state, the New Hampshire tax is reduced to the amount of the tax of the state of residence and what it would impose. Employers are required to withhold 4% of the non-resident's income. However, even if his home state would tax him less than the full 4%, any excess tax was held as refunded to the non-resident upon his filing of a New Hampshire tax return after the close of the tax year, showing that he is entitled to be taxed at a rate less than that of 4%. The commuter's income tax initially imposes a tax of 4% as well on any income earned by New Hampshire residents outside the state of New Hampshire. It then exempts such income from tax. However, 1, if it is taxed by the state from which it is derived, or 2, it is exempted from taxation by the state from which it is derived, or 3, if the state from which it derives is not tax income. The effect of the imposition on exempting features is that no resident of New Hampshire is taxed on his or her out-of-state income, nor is the domestic earned income of a New Hampshire resident taxed. In effect, then, the state taxes only the income of non-residents who work in New Hampshire. It is on the basis of this disparate treatment of residents and non-residents that appellants challenge New Hampshire's right to tax their income from their employment in that state. 2. The Privileges and Immunities Clause, Article 4, Section 2, Clause 1 of the U.S. Constitution provides, quote, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, close quote. This clause thus establishes a norm of comity without specifying the particular subjects as to which citizens of one state coming within the jurisdiction of another are granted equality of treatment. The origins of the clause do reveal, however, the concerns of central import to the framers of the Constitution. During the pre-constitutional period, the practice of some states denying to outlanders the treatment that its citizens demanded for themselves was widespread. The fourth of the Articles of Confederation was intended to arrest this centrifugal tendency with some particularity. It provided, quote, the better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this Union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice excepted, shall be entitled to all the privileges and immunities of free citizens in the several states, and all the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions of the inhabitants may enjoy thereof. End quote. The discriminations at which the clause was aimed were by no means eradicated during the short life of the Confederation, and the provision was carried over into the comity article of the Constitution in a briefer form, but with no change of substance or intent, unless it was to strengthen the force of the clause in fashioning a single nation. Thus, in the first and long the leading explication of the clauses, Mr. Justice Washington, sitting as Circuit Justice, deemed the fundamental privileges and immunities protected by the clause to be essentially coextensive with those calculated to achieve the purpose of forming a more perfect union, including, quote, an exemption from higher taxes or impositions than are paid by the citizens of the state, close quote. In resolving constitutional challenges to state income measures, this court has made it clear that, quote, in taxation, even more than in other fields, legislatures possess the greatest freedom in classification, close quote. A review of tax classifications has generally been concomitantly narrow, therefore to fit the broad discretion vested in the state legislatures. When a tax measure is challenged as an undue burden on an activity granted special constitutional recognition, however, the appropriate degree of inquiry is that necessary to protect the competing constitutional values from erosion. The consideration applies equally to the protection of individual liberties and the maintenance of our constitutional federalism. The Privileges and Immunities Clause, by making non-citizenship or non-residence an improper basis for locating a special burden, implicates not only the individual's rights to non-discriminatory treatment, but also, perhaps more so, the structural balance essential to the concept of federalism. Since non-residents are not represented in the taxing state's legislative halls, judicial acquiescence in taxation schemes that burden them particularly would remit them to such redress as they could secure through their own state. But, quote, to prevent retaliation was one of the chief ends sought to be accomplished by the adoption of the U.S. Constitution, close quote. Our prior cases, therefore, reflect an appropriately heightened concern for the integrity of the Privileges and Immunities Clause by erecting a standard of review substantially more rigorous than that applied to state tax distinctions among, say, forms of business organizations or different trades and professions within a single state. The first such case was Ward versus Maryland, a 1871 case, challenging a statute under which non-residents were required to pay $300 a year, and that's 1871 money, for a license to trade goods not manufactured in Maryland, while resident traders paid a fee varying from $12 to $150, depending on the value of their inventory. The state attempted to justify this disparity as a response to the practice of runners from industrial states selling by sample in Maryland. free from local taxation and other overhead expenses incurred by resident merchants. It portrayed the tax as a fee upon particular businesses or trade carried on in a particular mode, end quote, rather than a discrimination against traders from all other states. Although tax may not have been palpably arbitrary, the discrimination could not be denied, and the court held that it violated the guarantees of the Privileges and Immunities Clause against, quote, being subject to any higher tax or excise than that exacted by the law of the permanent residence. In Travelers Insurance Company versus Connecticut, a 1902 case, the court considered a tax laid on the value of stock in local insurance corporations. The shares of non-resident stockholders were assessed at their market value, while those owned by residents were assessed at market value less the proportionate value of all real estate held by the corporation and on which it had already paid a local property tax. In analyzing the apparent discrimination thus worked against non-residents, the court took account of the overall distribution of the tax burden between resident and non-resident stockholders. Finding that non-residents paid no local property taxes, while residents paid those taxes at an average rate approximating or exceeding the rate imposed by the state on non-resident stock, the court upheld the scheme. While more precise equality between the two classes could have been obtained, it was, quote, enough that the state had secured reasonably fair distribution of burdens and that no intentional discrimination has been made against non-residents, close quote. Their contribution to state and local property tax revenues, that is, was no more than the rateable share of their property within the state. The principles of Ward and Travelers were applied to taxes on non-residents' local incomes in Schaefer v. Carter, a U.S. Supreme Court case from 1920, and Travis v. Yale and Town Manufacturing Company. Upheld the Oklahoma tax on income derived from local property and businesses by a non-resident, where the state also taxed the income from wherever it was derived of its own citizens. Putting aside the theoretical distinctions and looking to the practical effect of operation of the scheme, the non-resident was not treated more onerously than the resident in any particular, and in fact was called upon to make no more than his rateable contributions to the support of his state government. The New York tax on residents and non-residents' income at issue in Travis, by contrast, could not be sustained when its actual effect was considered. The tax there granted personal exemptions to each resident taxpayer for himself, for each dependent, but it made no similar provisions for non-residents. The disparity could not be, quote, deemed to be counterbalanced by an exemption for non-residents' interest and divided among income because it was not likely to benefit non-residents to a degree corresponding to discrimination against them. Looking to the concrete and particular instance of the tax. Therefore, the court said that many New Jersey and Connecticut residents who worked in New York, quote, they pursue their several occupations side by side with residents of the state of New York, in effect competing with them as to wages, salaries, and other terms of employment. Whether they must pay a tax upon the first $1,000 or $2,000 of income, while their associates and competitors who reside in New York do not, makes a substantial difference. This is not a case of occasional or accidental inequality due to circumstances personal to a taxpayer, but a general rule operating to the disadvantage of all non-New York residents and favoring all New York residents. There you go. Section 3. Against this background, establishing a rule of substantial equality of treatment for the citizens of the taxing state and non-resident taxpayers, the New Hampshire commuter's income tax cannot be sustained. The overwhelming fact, as the state concedes, is that the tax falls exclusively on the income of non-residents, and is not offset even approximately by other taxes imposed on residents alone. Rather, the argument advanced in favor of the tax is that the ultimate burden it imposes is, open quote, not more onerous in effect on non-residents because their total state tax liability is unchanged once the tax credit they receive from their state of residence is taken into account. While this argument has an initial appeal, it cannot be squared with the underlying policy of comity to which the Privilege and Immunity Clause commits us. According to the state's theory of the case, the only practical effect on the tax is to divert New Hampshire tax revenue that would otherwise be paid to Maine. In effect, entirely within Maine's power to terminate by repeal of its credit provision for income taxes paid to another state. The Maine legislature could do this presumably by amending the provisions so as to deny a credit for taxes paid to New Hampshire while retaining it for those of the other 48 states. Putting aside the acceptability of such a scheme and the relevance of any increase in applicants' home state taxes that the divisionary effect is said to have, we do not think the possibility that Maine should shield itself from residents of New Hampshire's tax cures the constitutional defect of the discrimination in that tax. In fact, it compounds it. For New Hampshire, in effect, invites applicants to induce their representatives, if they can, to retaliate against New Hampshire. A similar, though much less disruptive, invitation was extended by New York in support of a discriminatory personal exemption at the issue in Travis case. The statute guaranteed the non-resident a credit for taxes paid to his state of residence on a New York-derived income, only if that state granted a substantially similar credit to New York residents who were subject to its income tax. New York contended that it thus, quote, looked forward to the speedy adoption of an income tax by all adjoining states, which would eliminate discrimination, quote, by providing similar exemptions similarly conditioned, end quote. To this, the court responded in terms fully applicable to the present case. Referring to the anticipated legislative response of the neighboring states, it stated, quote, this, however, is wholly speculative. New York has no authority to legislate for the adjoining states, and we must pass upon its statute with respect to effect in operation in the existing situation. A state may not barter away the right conferred upon its citizens by the Constitution of the United States to enjoy the privileges and immunities of citizens when they go into other states, nor can discrimination be corrected by retaliation. To prevent this was one of the chief ends sought to be accomplished by the adoption of our federal Constitution. Nor, may we add, can the constitutionality of one state statute affecting non-residents depend upon the present configuration of the statutes of that other state. Since we dispose of this case under Article 4, Section 2 of the Constitution, we have no occasion to address the equal protection arguments directed to the disparate treatment of residents and non-residents, and that feature of the statute that causes the rate of taxation imposed upon non-residents to vary among them depending on the state they reside in. Reversed. Justice Douglas took no part in the consideration or decision of this case. Okay. Justice Blackburn dissented. Figures. Justice Blackburn says, for me, this is a non-case. I would dismiss the appeal for want of a substantial federal question. We have far more urgent demands upon our limited time in this kind of litigation, and you're writing a dissent. Okay. Because the New Hampshire income tax statute operates in such a way that no New Hampshire resident is ultimately subjected to the state's income tax, the case is at first glance appears to have some attraction. That attraction, however, is superficial and upon careful analysis promptly fades and then disappears entirely. The reason these applicants, who are residents of Maine, not of New Hampshire, pay a New Hampshire tax is because the Maine legislature, the applicants' own duly elected representatives, has given New Hampshire the option to divert this increasement of tax on a Maine resident's income earned in New Hampshire from Maine to New Hampshire, and New Hampshire willingly has picked up that option. All that New Hampshire has done is what Maine specifically permits, and indeed invites it to do. If Maine should become disenchanted with its bestowed bounty, its legislature may change the Maine statute. The crux is a statute of Maine, not a statute of New Hampshire. The applicants, therefore, are really complaining about their own statute. It is ironic that the state of Maine, which allows a credit, has made an appearance in this case as an amicus urging, in effect, the denial of the credit by an adjudication of unconstitutionality of New Hampshire statute. It seems to me that Maine should be seeking here to uphold its own legislatively devised plan or turn its attention to its own legislature. One wonders whether this is just a lawyer's lawsuit. Certainly the appellants, upon prevailing today, have no direct or apparent financial gain. Relief for them from the New Hampshire income tax results only in a correspondingly pro tanto increase in their Maine income tax. Dollar-wise, they emerge at exactly the same point. The single difference is that their state, Maine, enjoys a tax on the New Hampshire earned income rather than New Hampshire. Where, then, is the injury? If there is an element of injury, is it Maine imposed? We waste our time, therefore, theorizing and agonizing about the privileges and immunities clause and equal protection in this case. But if that exercise in futility is nevertheless indicated, I see little merit in the applicant's request for relief. It is settled that absolute equality is not a requisite under the Privileges and Immunities Clause, and I fail to appreciate unconstitutional, unequal protection on New Hampshire's part. If inequality exists, it is due to the differences in the respective income tax rates of the states that border upon New Hampshire. I say again, this is a non-case, made seemingly attractive by high-sounding suggestions of inequality and unfairness. The state of Maine has the cure within its grasp, and if the cure is of importance to it and its citizens, such as the appellants, it and they should be about adjusting Maine's house, rather than coming here complaining of a collateral effect of its own state statute. Good point. All right, we got one case left, folks. One case left for the evening. Considering the constitutional limitations on choice of law for interstate discrimination. Now, wet the whistle a bit. Fill the lungs a bit, get the airflow going. Get oxygenated, get nicotinated. All right. Let's do this. G.D. Searle and Company versus Cohn. U.S. Supreme Court case 1982. Justice Blackmun delivered the opinion of the court. A New Jersey statute from 1952 pulls the limitations on a period of action against a foreign corporation that is amenable to jurisdiction in New Jersey courts, but that has in New Jersey no person or officer upon whom process may be served. The U.S. Courts of Appeals for the Third Circuit in this case held the statute does not violate the Equal Protection and Due Process Clause of the 14th Amendment. We agree. We vacate the Court of Appeals judgment and remand the case for consideration of petitioner's Commerce Clause challenge to this statute. 1. Respondents Susan and Walter Cohn are husband and wife. In 1963, Susan Cohn suffered a stroke. 11 years later, in 1974, the Cohns sued petitioner G.D. Searle and Company in Superior Court of New Jersey, Essex County, alleging that Susan Cohn's stroke was caused by her use of an oral contraceptive manufactured by petitioner. Petitioner was severed under New Jersey's long-arm rule. New Jersey Court Rule of Procedure 4-4-4C1. Petitioner removed the suit to federal court and thereafter moved for summary judgment based upon New Jersey's 2-year statute of limitations. New Jersey Statute, Section 2A 14-2, 1952, governing an, quote, action at law for an injury to the person caused by a wrongful act, close quote. Respondents countered with Section 2A 14-22. That section tolls the statute of limitations for cause of action against a foreign corporation that is, quote, not represented in New Jersey by any person, officer, whom summons may be served upon. The district court ruled that petitioner was not represented in New Jersey for the purposes of the tolling provision. Nevertheless, it held the respondent's suit was barred. Does make sense? According to the district court, the tolling provision had operated to preserve only causes of action against corporate defendants that were not subject to in personam jurisdiction in New Jersey. With the enactment of New Jersey's long-arm rule now, New Jersey Court Rule 4-4-4C, the rationale for the pre-existing tolling provision ceased to exist. On this reasoning, the court held that the tolling provision served no logical purpose, found it invalid under the Equal Protection Clause, and ruled that the 2-year statute of limitations therefore barred respondent's suit. Respondents appealed. Before the Court of Appeals reached a decision, however, the Supreme Court of New Jersey decided Zelmos versus Marin Engineering Corporation. That court ruled, as a matter of New Jersey law, that the tolling provision continued in force despite the advent of a long-arm jurisdictional rule. In addition, the court concluded that the tolling provision did not violate any equal protection or due process clauses of the 14th Amendment, because the increased difficulty of out-of-state service provided a rational basis for tolling the statute of limitations in a suit against an unrepresented foreign corporation. The Court of Appeals then followed the New Jersey Supreme Court's lead and reversed the district court, summing up what it felt to be the rational basis for the tolling provision. The Court of Appeals explained, quote, Since service of process under the long-arm statute is more difficult and time-consuming to achieve than service within the state, and since out-of-state non-represented corporate defendants may be difficult to locate, let alone serve, tolling the statute of limitations protects New Jersey plaintiffs and facilitates their lawsuits against out-of-state defendants. Because of the novel and substantial character of the federal issue involved, the Supreme Court grants certiorari. 2. Like the Court of Appeals, we conclude that the New Jersey statute does not violate the Equal Protection Clause. In the absence of a classification that is inherently invidious or that impinges upon fundamental rights, a state statute is to be upheld against equal protection attack if it is rationally related to the achievement of a legitimate government end. This is called rational basis review. It's a standard review. The New Jersey tolling provision needs to satisfy only this constitutional minimum, as the court explained in Chase Securities versus Donaldson. Quote, statutes of limitation represent a public policy about the privilege to litigate. Their shelter has never been regarded as what now is called a fundamental right, or what used to be called a natural right of the individual. He may, of course, have the protection of the policy while it exists, but the history of pleas of limitation shows them to be good only by legislative grace and to be subject to a relatively large degree of legislative control. Citing from Campbell v. Holt, petitioner insists the tolling statute no longer is rationally related to a legitimate state objective. Repeating the argument it made below, petitioner claims that the statute's only purpose was to preserve causes of action for those New Jersey plaintiffs unable to obtain in personam jurisdiction over unrepresented foreign corporations. With the presence now of long-arm jurisdiction, petitioner contends there is no longer a valid reason for tolling the limitation period for a suit against an amenable foreign corporation without a New Jersey representative. We note at the outset and in passing that petitioner's argument fails as a matter of state law. The New Jersey Supreme Court disagreed with petitioner's interpretation of the statute. The court observed the state's original tolling provision did not mention corporations and thus treated them like all other defendants. In 1949, the state's legislature amended the statute and exempted corporations except those foreign corporations not represented in New Jersey. Consequently, the court reasoned, the tolling provision was not rendered meaningless by the subsequent acceptance of the long-arm jurisdiction. As construed by the highest judicial authority in New Jersey law, the meaning of the tolling statute cannot be confined as narrowly as the petitioner wants it to be. When a statute is examined under the Equal Protections Clause, it survives petitioner's constitutional challenge because rational reasons support tolling the limitation period for unrepresented foreign corporations despite the institution of a long-arm jurisdiction in New Jersey. First, the unrepresented foreign corporation remains potentially difficult to locate. Long-arm jurisdiction does not alleviate this problem since a New Jersey plaintiff must find the unrepresented foreign corporation before it can be served. It is true, of course, that respondents had little or no trouble locating this particular well-known defendant petitioner, but the tolling provision is premised on a reasonable assumption that unrepresented foreign corporations, as a general rule, may not be so easy to find and serve as this one was. Second, the institution of the long-arm jurisdiction of New Jersey has not made service upon an unrepresented foreign corporation the equivalent of service upon a corporation with a New Jersey representative. The long-arm statute, NG Court Rule 4-4-4C1, prescribes conditions upon the extraterritorial service to ensure that New Jersey's long-arm jurisdiction has been properly invoked. In Behemoth, the New Jersey Supreme Court explained, open quote, under our rules, extraterritorial service is not simply an alternative to service within the state. Plaintiffs may not resort to out-of-state service unless proper efforts to effect service in New Jersey have failed. The rule imposes a further burden on plaintiff by requiring him to gather sufficient information to satisfy the courts that service is consistent with the due process of law. Thus, there are burdens a plaintiff must bear when he sues a foreign corporation lacking a New Jersey representative that he would not bear if the defendant were a domestic corporation or a foreign corporation with a New Jersey representative. In response to these rationales for treating unrepresented foreign corporations differently from other corporations, petitioner argues the tolling provision is unnecessary. Petitioner cites New Jersey Court Rule 4-2-2 and contends that a plaintiff can preserve his cause of action against a hard-to-locate corporate defendant by filing a complaint and thereby halting the running of the limitation period. but this is not an adequate substitute for a tolling provision. A court may dismiss a case if it has not been prosecuted after 6 months. In fact, New Jersey Court Rule 1-13-7, or if summons is not issued within 10 days after filing the complaint, New Jersey Court Rule 4-4-1. In any event, a state may provide more than one solution for a perceived problem. The Court of Appeals appropriately commented, quote, "Nothing in law or logic prevents the New Jersey legislature from providing New Jersey plaintiffs with a mechanism for relief from the burdens of suits conducted against non-represented foreign corporations, which is additional to any mechanism found in normal court rules." Petitioner also argues that a New Jersey plaintiff's burdens do not justify leaving a defendant open to suit without any time limit. In Valhamos, however, the New Jersey Supreme Court expressly authorized an unrepresented foreign corporation to plead another defense in response to a tardy suit. While the tolling provision denies an unrepresented foreign corporation the benefits of the statute of limitation, the corporation, the court stated flatly, remains free to plead laches, quote, "If a plaintiff's delay is inexcusable and has been resulted in prejudice to the defendant, the latter may raise the equitable defense of laches to bar the claim," close quote. Thus, under New Jersey law, an amenable, unrepresented foreign corporation may successfully raise a bar to plaintiff's suit if the plaintiff's delay cannot be excused and the corporation has suffered prejudice. In sum, because of the burdens connected with servicing unrepresented foreign corporations, we agree with the Court of Appeals and the New Jersey Supreme Court that the tolling provision does not deprive an unrepresented foreign corporation of the equal protection of the laws. This court remanded for consideration of a Commerce Clause challenge to the New Jersey statute. Justice Powell, joined by Chief Justice Berger, concurred with parts 1 and 2 of the court's opinion, but dissented from part 3, feeling that it was appropriate for the court to consider and determine the Commerce Clause issue. They expressed no opinion, however, on the merits of that issue. We really need to consider this, guys, but I'm not going to tell you. Okay. Justice Stevens, that motherfucker, dissenting. The equal protection question in this case is novel. I agree with the court that there is a rational basis for treating unregistered foreign corporations differently from registered corporations because they are somewhat more difficult to locate and serve with process. Thus, a provision that merely gave plaintiffs a fair opportunity to overcome these difficulties, for example, a longer period of limitations for suits against such corporations, or a tolling provision limited to corporations that had not filed the concurrent address with the Secretary of State, would be unquestionably permissible. But does it follow that it also rational to deny such corporations the benefit of any statute of limitations? Because there is a rational basis for some differential treatment, does it automatically follow that any differential treatment is constitutionally permissible? I think not. In my view, the Constitution requires a rational basis for the special burden imposed on this disfavored class, as well as a reason for treating that class differently. The court avoids these troubling questions by noting that the New Jersey Supreme Court has stated that an unrepresented foreign corporation may plead the defense of laches in the appropriate cases. But there are material differences between laches, which requires the defendant to prove inexcusable delay and prejudice, and the bar of limitations, which requires no such proof. Thus, the availability of this alternative defense neither eliminates the differential treatment, nor provides a justification for it. The defense merely lessens its adverse consequences. I can find no legitimate state purpose to justify the special burden imposed on unregistered foreign corporations by the challenge statute. I would reverse the judgment of the Court of Appeals. Thank you, Justice Stevens. And that, I believe, let me double check my notes. I think that does it for today's conflict of law reading. Let's see. Yes, sirs and ma'ams, that does it. So, tip your waitresses, tip your bartenders. Thanks for watching me read Conflict of Law. We'll see you all on the flip side.